สวัสดีครับ Good afternoon, everyone, and very welcome to the International Sharing Session on Draft Royal Decree on the supervision of digital platform services subject to prior notification. On behalf of Section Development Team,
Where's the theory book? I need the theory book.
I would like to thank you for taking your time this afternoon to join our session. My name is Tiniti Thatwatananont, and I will be your host for today's session. First of all, I would like to inform that this session is a unidirectional communication to provide explanations for previously received queries only. We gather all queries and comments to answer in the Q&A session. Therefore, we would recommend you mute your microphone and turn off video during today's session. The session today take about 2 hours. Now, I would like to invite Dr. Chaichana Mitrpant, Executive Director of ETDA, set the stage and give us the opening remarks and update the status of draft of Royal Decree. Thank you.
สวัสดีครับ and good afternoon. Dear participants, I think this is another chance of communication between ETA and stakeholders in this area, the regulation of the digital service platforms. And we have been receiving comments and opinion on these topics during the past few months. We value the comments and opinions greatly. And after we have received the comments, we have tried to adjust where possible already, and we have released the modified version of the draft royal decree a few weeks ago. I hope you had a chance to take a look, and you can see, well, I would say a big change in the content of the royal decree, mainly the duty of the digital service platforms. This has been greatly modified, and I hope that relieves some of the concern from the stakeholders. Maybe I recap a little bit on the principle of the draft royal decree. The main objectives of this royal decree is to for the digital service platform to notify ETA prior to operating the services. And the notification can be done electronically or online. Once the notification submission has been completed, the operation can start immediately. It doesn't need to wait for approval for the service, for the application to be approved. Another objective is to set standard for digital platform services in order to promote transparency and fairness, in order to protect online consumers. The third objective is for ETDA to have necessary information about digital platform services in order to evaluate risk that come with the operation of the digital service platforms, so that we can evaluate the level of interaction between the government and the platform in three different aspects. The first one is the financial and commercial security aspect. We would like to make sure that the risk regarding financial and commercial stability of digital transactions remain secure. The second aspect is uh, the reliability and credibility of the data message systems being used in the platforms. If higher risk in this aspect, then we might need to uh, uh, have a stronger measure to take care of the digital service platform. And the third aspect is to prevent loss to the public. If from the data that we collect, uh, uh, we see the signal of the risk in one of these three aspects rising up, then we need to take a cautious measure to mitigate the risk. The fourth objective is to make sure that the platform users has necessary information for them to use the platform effectively and with confidence. The fifth, um, the fifth objective of this royal decree is um, to provide for the punishment of the wrongdoing um, according to the Electronic Transactions Act. Um, so if this law decree is passed and the platforms that satisfy the requirements of the notification regulation and they don't submit the application um, or notify ETDA, then they're subjected to the punishment. And that will being stressed uh, in this royal decree as well. And the sixth objective is to promote the cooperation among the stakeholders, uh, in particular with different regulators and also the platform operators themselves, in order to make sure we have digital transactions or e-transactions uh, being conducted with the Thai people or in orders. And uh, quite a few people have been asking it what's the current status of the draft royal decree now. Um, so maybe I'll now provide you with an update on the current status. Um, ETDA is the organization that perform uh, routine jobs for the Electronic Transactions Commission established under the Electronic Transactions Act. So this job in particular, ETDA has drafted the royal decree uh, and then we proposed to the Electronic Transactions Commission, which is the body that will approve the draft and propose the draft to the Minister of MDES, Ministry of Digital Economy and Society. So we have gone through the first step. So we draft the decree. We went through public hearing, consultation, focus groups uh, for almost a year now. And then we proposed the draft to the Electronic Transactions Commission through the subcommittee on the legal issues. Um, and the minister has already passed the draft to the Deputy Prime Minister. The Deputy Prime Minister already passed the draft to the Secretariat of the Cabinet. So now we are at the stage where the draft is being tabled for the Cabinet to decide. If the Cabinet approve the principle of the draft, then the Cabinet will um, will propose No, I'm sorry. We'll hand in the draft to the Council of the State for reviews, and then after the review revision, then the Secretariat of the Cabinet will process the royal decree to the King um, to affix the signature, and then um, in the end, it will have to be published through the Royal Gazette. I would like to ensure that the issues that we have taken, we have tried to put in the current draft, but there's still remaining uh, a few issues, and that will collect and at the stage of the Council of the State reviews, we will present all these issues to the committee set up by the Council of the State. And we would like to make sure that uh, we have a communication channel still open for all stakeholders to submit further um, views, opinions, suggestions, and case study data that we can use to support the argument. Um, and those we will try to collect and present at the stage of the review of the Council of the State. And maybe let me remind all of you that the written comments can be submitted through email at the um, ICT Law Center at etda.or.th. I think we will put that up on the presentation uh, toward the end of the session today. So that's the current status of the draft law, and we expect the cabinet to consider this draft law in a few weeks. Um, and we will keep you guys updated on the status. And again, we always welcome your comments. Uh, Maybe at this stage, I give back the stage to our moderator, Kunpiniti. Thank you.
All right, thank you, Dr. Chaichana, for the principle and update status of the draft of the royal decree. And now let's begin the Q&A session. In this session, Ms. Supachitra Lauha Pinyo, Senior Management Staff, Digital Law Center of ETDA, will ask Dr. Chaichana to answer or clarify queries and concerns which ETDA has received from everyone prior to this session. Please let us inform that the number of all questions or concerns will be divided to 10 main topics as following. The first one is scope and definition. The second is obligation for foreign digital platform service provider. The third is adopting legal representative in Thailand. The fourth is data breach and trade secret. The fifth is compliance obligation. The sixth is damage remedy measure. The seventh is Section 18, formerly Section 16. The eighth is cooperation with government authorities. The ninth is duration, and the 10th is penalty. From now on, I will give the stage to Ms. Supachitra and Dr. Chaichana. Thank you.
Good afternoon, everyone. In this session, I will ask the queries and concerns which ETDA has received from private sector and categorize it as mentioned by Kunpiniti. After this session, we do hope that everyone will have better understanding about the draft. Let's begin with the first topic, which regards on the scope and definition of the digital platform services. Main concern is about the definition, which deemed to be too broad. In addition, which type of digital platform services fall under this draft such as B2B platform, subscription video on demand platform, video conference platform, and online payment service. Some suggestion is to exclude the digital platform service that does not have transactions such as social media. So the first question should be, what is the reference of the definition of digital platform services? Does it align with the international or business understanding? And how to identify what digital platform service is inside or outside the scope of the draft of Royal Decree. The second one is that there is a question about the scope of the royal decree, which seems potentially to be beyond the scope of the Electronic Transactions Act and the scope of the Electronic Transactions Development Agency. So I will give the floor to Dr. Chaichana.
Yes, the first question deal with scope and definition. And as we have been communicating in several sessions earlier, that we have looked through several legislation in Europe, in Asia, in the US, and in the end, we look closely into the EU framework. In particular, we look at the P2B or platform to business regulation of EU, and we also look at the Act on Improving Transparency and Fairness of Digital Platform of Japan. And we we believe that our definition is very much in line with the definition specified in these laws. So digital platform services uh, means the services that being offered through a platform or a site. So the site is a place where business user and consumer meet and interact on the platform. So there must be at least three parties. First is the platform itself. Second one is the business user. The third one is the consumer. So if there are at least three parties, then the platform will fall in the scope of this draft royal decree. Whereas in the case a business user develop its own information system to communicate with the consumer directly without a third party or the platform, this kind of system will not fall under the scope of this royal decree. So that's the where about the definition of the digital platform services that uh, we look at. And the concern with the scope of the Electronic Transactions Act, um, if you have, if you look at the definition provided in the Electronic Transactions Act, you can see the definition of electronic transactions. Electronic means data messages, which collectively it covers anything that conducted using electronic means. For example, when a person send a message to another person through email, through instant messaging system, through a website, all these examples are included under the scope of Electronic Transactions Act. And ETDA is the organization acting as a secretariat body for the Electronic Transactions Commission, whose authority and responsibilities include to promote the use of electronic transactions and regulate any business providing digital services related to electronic transactions. Therefore, is indeed ETDA's duty to propose to the Electronic Transactions Commission where appropriate for the regulation. And from what we have seen through our operation of the online consumer complaint center by the four-digit telephone numbers 1212. Each year, we receive more than 40,000 cases for the past 3 years, and about half of those cases are from online e-commerce problems and issues. So we have seen the need for the uh, regulation on the digital service platforms, but still, we still need more data to evaluate the risk in order to make sure that we apply appropriate level of measures, not being too stringent or strong to be cumbersome for the business to operate, but also not too weak uh, uh, so that the measure is not enough to protect the consumer. So our first step is to suggest this draft with the weakest level of regulation, which is the prior notification before running the digital service platforms. And that's the scope of our work and where the definition we derive from. To recap, from the P2B regulations from the EU and also from the Act on Improving Transparency and Fairness of Digital Platform of Japan. I just would like to remind that um, whatever we are proposing, we look at international practice and framework and try to make sure that what we are doing is in line with international framework and practice. And if you see anything that is our place, we welcome comments and suggestions all the time. Thank you.
Thank you. Let's move to the second topic, which relates to the obligation for foreign digital platform service provider. The reason of setting some characteristic of foreign digital platform service provider, which aims to provide the service to consumer in Thailand under Section 8, Paragraph 2. Some views that the result displayed on the website in Thai language does not imply that the digital platform service provider intends to provide services to Thai consumer. Also, there is suggestion that this section should cover the case where digital platform service provider has server deployed in Thailand. Moreover, if the foreign digital platform service provider comply with the law, the draft, it will breach the obligation under Business Foreign Act. So the question should be, what is the purpose of Section 8, which expand the scope of digital platform service provider who have an establishment outside Thailand?
This is one of the major concerns, in particular, from the platform service providers which has a permanent establishment outside Thailand. And indeed, this is an issue that we have observed through our OCC, or Online Consumer Complaint Center. Um, from the statistics, uh, we can resolve about 80% of the cases reported through OCC 1212, with almost 20% of the cases being reported we could not resolve, and majority of those unresolved cases uh, uh, the transactions are conducted through platforms that operate outside Thailand. For example, social media platforms, where we don't have mechanism to communicate and to enforce um, the 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 rights of the consumer in Thailand, and that's why we propose under this draft law to also include the services offered by the foreign digital platform service providers, and the conditions to include the platform service providers residing outside Thailand is provided in, I believe, Section 8. Um, and I think majority of those conditions are from the international framework, such as GDPR. Uh, so we think the proposed draft is already in line with the international thinking on the scope, how to include services offered by foreign digital platform. I'm not sure I cover all the points. Please confirm, Kun Subhachitra.
Okay. Maybe there are the question about the 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 foreign digital platform um, must be like, sorry, um, maybe about the issue on Foreign Business Act, that the comments concern that if if the foreign digital platform service provider comply with this draft, it will breach the obligation under Business Foreign Act.
I believe that under the Foreign Business Act, platforms operating outside Thailand, providing services in Thailand, must be registered through an organization specified under Foreign Business Act. And if uh, um, you're the platform already registered under Foreign Business Act, you can also notify ETDA if you provide services to the Thai citizen. And there's no conflicting rule between these two laws. I believe that's the issue.
Okay, so let's move to the third topic. The third topic relates to the second topic. Once the foreign digital platform service provider aims to provide the service to Thai consumer, such foreign digital platform service provider is required to appoint legal representative within Thailand. Main concerns in this topic regards about: first, the necessity of the legal representative. If digital platform service provider already has channel to communicate with Thai customer. Second, the scope of liability of representative, which should not cover other laws such as tax liabilities, because it may deem as creating a permanent establishment in Thailand, as well as the quality or the qualification of the legal representative. For example, should it have Thai nationality or must be the third party? Third, concern about impact on business structure and conflict of international law by setting the condition to get access to the Thai market.
Thank you, Kunbo, to raise concerns in this regard. Um, as I suggested earlier, that from our statistic in the OCC, more than almost 20% of the cases where we could not resolve has something to do with foreign digital platform services, uh, in particular the one that doesn't have representatives in Thailand. So in order to address this pain, we put that in the draft royal decree so that the foreign digital service provider must have a legal representative in Thailand. But the duty of the legal representative is to oblige to the conditions specified under this law only, with no other obligations, and that doesn't have to do with permanent establishment issue, and doesn't have anything to do with the business structure or access to Thai market. The access to Thai market is open. So if you are a digital service platform operating today, you have access already today. What you have to do when this law become effective is to notify ETDA according to the forms, which we'll discuss a bit later, and with the duty to report to ETDA annually on the updates of the information. And that does not in any way have limitation on the access to Thai market.
Okay, so the fourth topic is about the concern on information. There are 5 sections which relate to this topic. Section 11 oblige digital platform service provider to submit information according to the form of notification. Section 13, paragraph 2 specify that ETDA, upon approval of Electronic Transactions Committee, shall prescribe information about digital platforms service provider, which can be publicized other than the information under paragraph 1. Section 15 requires that if other authorities need to request information that ETDA received from the notification process, ETDA must getting approval from Electronic Transactions Committee on the case-by-case basis. Section 16 allows ETDA to request information provided by the digital platform service provider to other authorities. And the last one is Section 18, paragraph 4, oblige digital platform service provider who operate certain type of digital platform service to submit the compliance report. The concern on taking care of information are about data breach or disclosure of confidential information. The inquirer concerns that the authority may disclose or leak the confidential information or trade secret, and the sharing of information between ETDA and the government authorities should be consistent with the Personal Data Protection Act.
Yes, regarding the issues dealing with data, as Kunbo has mentioned, there are several sections under the draft law dealing with data and information. And well, the main objective for ETDA is to understand the risk associated with the services provided by the platforms. And let me remind you that we will evaluate the risk from 3 aspects. The first is of interest of financial and commercial security. The second one, we want to make sure the trustworthiness of the reliability of the electronic information systems. And the third aspect is in the interest of preventing the occurrence of the loss to the public. So the information being requested from the digital service platforms, we try to collect data in order to evaluate the risk associated with the 3 aspects that I mentioned. And the information being received can also be shared with other government organization subject to the approval of the Electronic Transactions Commission. The sharing of this data come into 2 aspects. The first one is to facilitate the activities that the platforms has to deal with a government organization. So if the platforms already provide data to one of the government agency, the government agencies try our best to exchange data so that we don't have to bother the platforms several times on the same data set. And that's one of the attempt that we provide for in this draft law. And if in any case, the data being submitted to ETDA is confidential, during our practice is to have an NDA or non-disclosure agreement if that is necessary, and we honor the confidentiality and the commercial aspect of the data being collected. So, and all these data to be collected, if this law is passed, uh, has not been decided yet. And we will, once the cabinet has approved the draft, if that's the case, we will start discussing possible data to be submitted under this draft law. And we would like to make sure that we try to reach out to all stakeholders if possible. So when that happens, uh, you guys can spread out the words so that we can receive opinions and comments as from many stakeholders as much as possible.
Thank you, Dr. Chaichana. So the purpose of the exchange between the government authorities information is to facilitate a platform for the same data sets which already submit to other authorities. So I think this is the main purpose of this section. Okay, so moving to the topic, the next topic. In this topic, there will be question related to the compliance obligation under this draft as following. The first question is whether the digital platform service provider need to receive an approval before operating business or not. I think this question is already answered by Dr. Chaichana on the the detail or the principle of the draft.
Yes, so there's no need, right,
Yes.
to wait for the approval
Mhm.
of the notification. Once the platform submit the forms, notification form online electronically, then the platform is eligible for operating automatically.
So then the next question is the inquirer asks details of information needed to be notified in the form under section 11 as well as compliance report under section 18 paragraph 4.
I think the basic information from our research. So as I inform you that we look at different legal frameworks, including the one from EU and the one from Japan. And what we have found is common data that they collect consists of, for example, the name of the digital platform services, the name of the digital platform service providers, representative, including contact information, place of business, which doesn't have to be in Thailand, type of digital platform service, numeric data indicating the size of business as well as the explanation on how to get such data. So these are examples of data being collected through different legal frameworks, such as the one in Japan and the one in EU. So we will start from this baseline, and then we will, I think, invite stakeholders to discuss about the necessity of collecting this data.
Okay, so the third question on this topic is there is a concern that allowing the competent authority to require additional document as it deemed appropriate under Section 11 is an over empowerment of authorities. Do you have any idea about this?
Yes, the the um, the criteria, the guideline, and the practice of the actions allowed by the royal decree will has to be considered and approved by the Electronic Transactions Commission. But before we propose all these guidelines and how to and rules, of course, we always talk to our partners and major stakeholders to make sure that the steps are practical, the steps are in line with international practice. Um, and I think that's the practice that we have already done. And we also would like to make sure that whatever we do not uh, um, cause uh, too much of a burden from the digital service platforms. So in this aspect, we are listening and welcome suggestion, examples from other countries, and we will do our best to put our action in line with international industrial best practice.
The last question in this topic is the detail of business side report under section 17. It is suggests that the requirement of annual business size report should be applied only for digital platform service provider operating in Thailand, and this measure should be on voluntary basis.
Um, as I mentioned before, that we are concerned mainly with the risk, and we are concerned also mainly with the Thai consumers. And the Thai consumers, they consume services from both the local service provider and international service providers. So, with similar view from Personal Data Protection Act, the government would try to do its best to protect the local consumer, even when it needs to communicate with foreign operators. And that's the reason behind we put the same measure for the local and international operators. Um, and some of the business may concern with the information regarding the size of the business. How is that measured? We have looked at the examples uh, being collected by different government, and then we are considering these examples. This example includes data such as number of users of the platforms in previous years, and we can discuss the number of users means maybe Thai users, and we can also further discuss what does it mean to be Thai user. Do we look at the IP address of the users, or what do we look at? And these details we still open for the discussion. Other data, as an example, includes the revenue of the platform. Maybe again, we look at the revenue from the Thai customer, or in that regard, we look at the fees or profits received from the business users, or we can look at the number of transactions. These are examples of data being collected by different governments under this kind of framework. And we look at these as an example, and we will open the discussion what kind of data is the most suitable for the platforms operating to provide service to the Thai consumers.
Thank you. We move on to the sixth topic. There is a concern on excessive power of ETDA under Section 21, formerly Section 20, which empower to order digital platform service provider to do anything to remedy or prevent the damages incurred from cessation of their business. Could you clarify the purpose of this clause?
Yes, I think this clause deal with the cessation of the operation of the business, meaning the if the business decide to terminate the platforms, and a lot of Thai people are or have been becoming dependent on the platforms, such as the current situation where the COVID-19 uh, force everybody to stay at home, and indirectly people uh, both from the consumer side and from the business user side get online, get on platform more and more, and their lives and their business are more dependent on the services of digital platforms. And the cessation of the operation of the digital platform services will greatly impact both the business and the business users and the consumers. So this clause allow ETDA to provide a measure to prevent the impact to the users, both the consumers and the business users, and to ensure that the platform has appropriate measure to take care of the users when they decide to stop their operations.
So this should relate for the principle of the draft that we want to protect the consumer in Thailand and the balance between transparency and fairness of the stakeholders in the platform. So the seventh topic will focus on all concerns about Section 18, formerly Section 16. This section was criticized in various aspects, such as the criteria to determine large digital platform service, burdensome to related parties, redundancy and conflict of the existing law, especially the Computer Crime Act, which already covered the notice and takedown procedure. How have we revised the draft of the royal decree based on the feedback we received?
Yes, as I mentioned earlier, we try to improve the draft with the concern not to put too much burden on the platforms, as that has been raised uh, in different discussion sessions that we talked with stakeholders, both on the regulatory side and also on the industrial side. There were concern with the overlapping of the regulatory area, and we try to do our best to demarcate where which different regulators are responsible. So under this draft law, we have a mechanism to provide exception for the platforms so that the platform that has already registered or notified existing or other domain-specific regulators already, they do not need to submit the form again to ETDA, and ETDA can use the data sharing mechanism under the law to receive the data necessary for the notification. And also the duty that the previous version of draft imposed on the platforms. Uh, I think most of them has been removed, um, uh, with the only the transparency part, meaning whatever has been requirement for the platforms to do. Now under this draft, the platform only need to declare how they are doing um, those functions. For example, the terms and conditions and restriction or suspension condition of the users on the platforms that has to be clearly put down in the terms and conditions, or the main parameters for the ranking and recommendation of the products and services or advertisement that should be declared for transparency. Also, rating and review is a different area that the platforms should declare how they do it if they have such functions on the platforms. If they don't have these functions, then they have nothing to declare. Or access and utilization of data deriving from the provision of services to business users, how the platform uh, take care of the data on the platforms. I think they should be transparent and provide fair use of the data being acquired through the operation of the platforms. And another important thing is the complaint and dispute settlement, and this how to the mechanism and the service level agreement, the time frame to settle a dispute. I think these are important parameters for the users to know. So if the platform they have information in this area, they should also provide to the users, and including the conditions for the content moderation and content filtering. We think that these are features that users are very much interested in. So terms and conditions related to these features should be clearly presented or declared to the user. So that becomes the main content of the new section 18. I'm not sure if I have covered the issues in this area.
Um, and how about the clause on the notice and takedown? Can we move to? I think now we move the mechanism of content notice and takedown to use by other section. Can we still encourage or support the stakeholders to do the notice and take down measure to for like for e-commerce platform, for delivery platform?
Uh, Yes, whatever we think is a good practice. I think we move that to section 25, where we try to promote the local industry or even international industry to agree upon a best practice. Um, for example, the notice and take down. I think that's an international practice that is adopted globally. So we can apply this principle to services offered in Thailand in different areas. And ETDA can act as a facilitator that invite stakeholders in different business areas to talk about this mechanism and how they can work together to make sure that their platform services uh, can ensure the effective operations of this principle. Another example of the best practice specified under Section 25 is uh, about the identity proving and authentication. And I think that is one of the areas of the concern with the fraud issues that we have collected through the OCC operations, where in a lot of cases we cannot identify uh, the fraudster on the platforms. And that a part of it is from the lack of strong identity proving and authentication mechanism. So under Section 25, we suggest the community or the industry come up with a best practice to uh, to allow stronger identity proving and authentication in order to mitigate the risk associated with the fraud that we have observed for the past few years.
Thank you. So we'll move to the topic, the next topic, which relates to the process of cooperation with governmental authorities concerning Section 27, formerly Section 25, which apply digital platform service provider to comply with the judicial or administrative order under this draft or other related law. In addition, Section 28, formerly Section 26, allow EDA to request cooperation from relevant authorities in using their existing authorities and performing a duty for purpose of more effective implementation of this draft. The concern under these matters are included as follows. First, Section 27 may not be applicable because EDA is because Electronic Transactions Act is the law empowering this draft. Thus, the obligation and responsibility of digital platform service provider should be limited to Electronic Transactions Act, not other laws. The second is the power of EDA should be limited to what is related to Electronic Transactions Act. Other authorities have independence on the investigation, prosecution, and supervision according to their laws. The question is, do these two sections stipulate obligations to digital platform service provider, or specify the cooperation concept.
Uh, Yes, as we all know that in digital space, people and organizations need to work together in order to make sure the effective execution and operation. I think Section 27 is a very basic provision of any draft law. So any platform should be cooperating and acting according to the court order um, that is related to this law. For example, if your platform already notified to ETDA and later on maybe forget to submit um, a report that is required for the submission, then maybe after the ETDA's officials go and try to encourage the submission again and again and again and nothing happens, maybe we need to use the judicial power in order to enforce the law. And I think in that case, the platforms I think should follow the court order. That's some of the example that I can provide. The use of this section. Um, and in section 28, um, as we have talked to consumers where they have pains that when they're dealing with fraud with e-commerce, they have to deal with several organizations. For example, the Office of Consumer Protection Board, or OCPB. Uh, in some cases, they have to deal with the banks because they want their money back from the fraud event. They have to deal with ETDA, and so many government organizations have to deal with, and in some cases they have to deal with the law enforcement, the police, or the Ministry of Digital Economy and Society, if they see some illegal content being put on the platforms and they want to block it. So with these different organizations, different authority, uh, in order to solve one issues for a specific customer, a lot of actions need to be done across different organizations. So Section 28 allow different organizations to work together and ensure that the rights of the consumer are protected. And without this mechanism, working in silos, as we all know, is not effective way of working. So Section 28 allow organizations to work together to solve customers' problems.
Thank you. We now moving to the 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 topic. Sorry. The next topic concern is about the extension of duration provided by this draft to comply certain obligation, which are as follows. The first, the implementation period under Section 2, which the inquirer suggested that the period of 180 days is insufficient for digital platform service provider to be ready for fully compliance with obligation under this law. The second is the period for digital platform service provider to remedy when they lack some information in the notification form under Section 12. Third, the period for business site report under Section 17. And the last one is the time frame for submit compliance report under Section 18.
Um, Yes, I think this topic is also another very important topic because we want to make sure that whatever is specified in the law and is practical and is doable. And from our discussion, from hearing from the expert groups, we come up with the the duration specified in the draft laws. Um, uh, and we feel that is sufficient already. In particular, we have already relieved some of the burden that we put in the first draft of the law already. So with the relief of the burden, I think the duration that's being specified in the law uh, uh, is the numbers that already pass through different considerations. But still, we're still open for the suggestion. If you have recommendations or suggestion with regard to the duration, please submit it through our channel. And um, for the benefit of the discussion uh, at the stage of the review under the Office of the Council of State, the evidence or the examples behind the suggestion will be very valuable, and that will provide strong evidence uh, for the argument uh, toward the suggestion.
Thank you. Now we are moving on to the last topic. It regards on concerns about the penalty under Section 24, formerly Section 22 of this draft and Section 44 of Electronic Transactions Act. First, Section 24 empowered the competent authority to give suspension order to the digital platform service provider who failed to comply with this draft until they fully comply or revoke the notification when they fail to remedy within 90 days. The inquirer suggests that the penalty should be limited to those who submit the false or untrue information and should not apply to those who intend to remedy their compliance. The second concern is on the Section 44 of Electronic Transactions Act, which sets the criminal penalty for digital platform service provider who operate business without notification to ETDA. Also, the concept of extended liability may contradict to the law on business organization and may be too broad and disproportionate.
Um, I think most of the penalty related to this draft law are already prescribed in the Electronic Transactions Act. So this prescription we cannot change since it is an act being approved already more than 20 years ago. Uh, but the conditions how these penalty applies, we are still open and we receive we welcome suggestion, and the suggestion that we have already received we will take into consideration in order to make sure that it doesn't put too much burden on the digital platform service provider. But also we have to balance uh, the consumer protection side so that the punishment should not be too light or under weak conditions, so that in such a way that consumers are not protected at all. And I believe that in this aspect we welcome recommendation for practice uh, during uh, or the precondition before applying the penalty already specified in the Electronic Transactions Act.
Thank you, Dr. Chaichana. We finished the Q&A session, so I will um, turn the floor to Kunpiniti.
All right, thank you, Kun Supachitra and Dr. Chaichana, for conducted the Q&A session. As our executive director mentioned that EDA still accept suggestion, recommendation about digital platform service. You can send to us at ictlawcenter@eda.or.th. And this session today will be uploaded on YouTube channel ETDA Thailand. And now, before we finish today, may I invite Dr. Chaichana to give a closing speech.
Um, we really appreciate the participation today, even though it's a one-way communication for today. But in overall picture, is many ways communication. We have channels open. Now, if you have comments, suggestion, you can submit it through ICT Law Center at etta.or.th, as Kun Piniti has mentioned. Um, but we just would like to control the environment of the communication so that it's more effective in terms of relaying messages. This doesn't mean in any way to limit the receive of your opinion or suggestion. We always welcome. You can uh, in the past, we have received written recommendation. We invited the parties provided the recommendation for discussion so that we understand the position, we understand the reasoning behind the suggestion and recommendation, and we will have this session throughout the period, still waiting for the time of the review at the stage of the Council of State. Um, so uh, we welcome all suggestions and recommendation again um, at any time, and we will keep you posted of the uh, updated status of the legislation. And if there's not update information on website or Facebook, you can contact us through email, through telephone. Even though we also under the work from home condition, we still can communicate with you through social media, through email, through phone systems. I think that's it for today. For any concerns being put, I'm not sure in the chat or in any other communication channel today, we'll again collect and try to respond. If we collect enough comments and suggestion, we might organize this kind of session to communicate with you guys again in the future. And again, thank you for participation, and um, we look forward to having more inputs from you guys, and we will try to organize a maybe a more interactive session in the future. Thank you very much for today.
Thank you, Dr. Chaichana, for the closing speech. And last but not least, may I introduce our upcoming event on 15 and 30 October 2021. Uh, it's about the seminar for the seminar digital video platform. For more information, please visit Facebook at Thailand. This is the end for today. Thank you everyone for sticking with us and have a nice day. Goodbye. สวัสดีครับ